So welcome everyone to tonight's session on access to information. This is the penultimate tutorial that we have, and we're certainly moving towards the end of the term, and it's something that's pretty welcome for all of us, because then it's an achievement. Again, there's that sense of accomplishment that we've completed a unit, and for some of you, well, for all of us, it would also mean that there was a lot of learning, hopefully, that came about as a result of staying on in the unit. And again, it's not just a question of, I would think it isn't just a question of trying to get marks or passing, a question of passing a unit. It's really more about preparing ourselves or preparing yourselves to become future lawyers, because you wouldn't want to get into a situation where you're trying to advise a client and you would have thought that you'd know the law, and then you say, you don't really know the law, mainly because you may not have really been preparing, reading enough about the material. So, but the fact that you would end up, completing the unit would suggest that you would at least have imbibed and learned a lot about administrative law. And so I congratulate all of you for completing the unit. I'm sure you will complete the unit successfully. And so, yeah, and then, you can look forward to a short break. So tonight we'll talk about access to information. Again, this is a very important topic because, as I will show later on, we recall, among others, and I'm going to go back to the Freedom of Information Act in a short while. But one of the key things that we often, that we should be mindful of is that there is no common law duty on the part of the executive to provide reasons for an executive decision. And we know as well that if a decision is based on an enactment, then it is possible to rely on the ADJR Act to compel the executive decision maker to provide reasons for a decision. But that is only when the ADJR Act is applicable. In other words, one, you have a ground for judicial review, and two, that the decision is actually made under an enactment. But in general, therefore, we know that because executive decision makers do not have any common law duty to provide reasons for a decision, if a decision has been made that is adverse to you or to an applicant, then it's difficult for you to make sense of why a decision was made against you. And so what remedy do you have? And we would ordinarily think, therefore, that the only remedy you have is really based on the ADJR Act. But again, that's problematic, as we said, because it has to mean that the decision was made based on an enactment, and secondly, that there was a ground for a judicial review. The Freedom of Information Act, actually, as we see later on, can provide a legal ground to compel, for an applicant to find out the reasons for a decision. It's something that we will explore in this tutorial. And we will also be, again, trying to examine the importance of the Freedom of Information Act and the access that is given to the public on the basis of the Freedom of Information Act to public documents, and what its role might be within the framework of administrative law. And so therefore, when we speak of administrative law, we simply cannot just speak in terms of possible, review remedies from the viewpoint of, from the viewpoint of the judiciary in the form of a judicial review or a merits review by the Administrative Appeals Tribunal. There are, in fact, other avenues by which the decisions made by the executive can actually be subject to control, or can actually be subject to public accountability. And we will examine, therefore, and explore the importance of the freedom on the part of the public to access public information. So tonight, after studying this topic, you should be able to discuss and explain the importance of freedom of information legislation, the key principles of the FOI Act, legal right of access under the FOI Act, and exemptions, conditional exemptions, and public interest factors under the FOI Act. Now, before I continue, I just wish to make a reminder that in relation to the final assessment, the final assessment is meant to be finished within 2 to 3 hours. So you shouldn't, if you're sitting down to try to finish the final assessment, you shouldn't be spending more than 3 hours. If you're spending more than 3 hours, you're overdoing it, because it's meant to be sat as if it were an invigilated exam. So you shouldn't spend more than 3 hours, which means therefore that even if you might be coming home from work, or you might have certain family obligations, the amount of time that you should be devoting to complete the final assessment should not exceed 3 hours. Okay, so beyond that, you are overdoing it. And I would expect answers to actually be concise. The more concise they are, the better. Okay, so make it simple. Okay, so having said that, before I continue again, would there be any questions or comments that anyone would wish to make?
Manjo.
So tonight we will cover 6 discussion questions to dig deep into the topic on freedom of information, including the quiz question that we have for the week, which is the final quiz question. Okay, so let's begin by talking about the role of the Freedom of Information Act 1982 Commonwealth in administrative law. What role does it play? Why are we... wait, hang on. Sorry, I may have muted myself or something. Oh, Kayla had a question. Okay, apologies. I think the speaker was off. Okay, Kayla, go on.
Can you hear me now, Manjo?
I could. Yeah, I don't know if the problem was mine or your microphone wasn't working. Either way, I didn't hear you. Yes, Kayla, go on.
I know we have a tutorial on Monday for review,
Yeah.
but would you be able to just confirm if the take-home paper is for weeks 6 to 11?
Mm-hmm.
Are you able to confirm that now? Because I'd like to print off all my notes.
Okay. So, the focus of the final assessment would be weeks 6 to 11, or I might say I may not be asking a question about on the basis of week 11. So maybe 6 to 10, or would you rather we include a question on the Freedom of Information Act? I was thinking, to make it tighter. 6 to 10, I think is fine. So we'll probably just focus on. I already have a question actually for the Freedom of Information Act, but. So if you have 6, 7, 8, 9, 10, that would be five chapters. So I think I will not have a, it's a good thing we're having the tutorial on the Freedom of Information Act, but probably I will not ask a question on the basis of week 11. So it's going to be from week 6 to 10. Having said that, though, I wish to provide a caveat, a warning, that even as we examine, week 6 to 10, because week 6 to 9 cover grounds for judicial review, and week 10 is about judicial review remedies. I wish to emphasize that although I'm saying that the topics will mainly focus on week 6 to 10, you need to be familiar with the prior topics, like when can you have judicial review, for example. So you need that. So I cannot. It's difficult for me to say that you don't need to remember what the previous topics were, because weeks 6 to 9, for example, are focusing on grounds for judicial review. But remember, if you're looking at applying for judicial review, you need to be aware of the elements, the jurisdictional elements that need to be met before you can apply for judicial review, right? So, for example, that basic question, you need to remember whether or not the decision is made on the basis of an enactment. You need to know if it was based on, if the executive decision was based on the exercise of implied executive powers, because then it will tell you cannot apply on the basis of the ADGR Act. So that's one point there. The other question that we need to remember always is the question of legal standing. Does the person applying for it have local standing? Now, I'm not saying that you need to traverse all of these jurisdictional elements. I just need you to know, or to be mindful of the fact that there are certain jurisdictional elements that need to be met before you can actually apply for judicial review. But the focus will really be on the grounds for judicial review, which would be covered by weeks 6 to 9, and then the judicial review remedies. So that shouldn't be too difficult. Okay, was that fine? It's from Jackson. I like FOI. So should we include a question on the FOI? Okay, everyone else does it. So.
No.
Okay. Can be very complicated, actually. The problem with the FOI, okay, the main problem with the FOI is that it's a lot of it is based on statute. You know, a lot of these exceptions are based on statute. When you deal with the, you know, when you deal with weeks 6 to 10, they're mainly based on jurisprudence, and they're easy to find. But in relation to the Freedom of Information Act, when you try to examine the, you know, is there an exemption for this? Can this be done? You're going to have to examine the FOI Act itself, which can really get very tricky. Like, for example, can you apply for, you know, can you compel the ASIO or maybe the defense, the Minister for Defense to allow you to see certain documents? That's really a difficult question to answer because you need to go to the statute. In fact, I'm asking a question today about that subject just to show how complex it can be. So maybe not. Yeah, from previous Jackson. Jackson looks like a movie star. Already has life easy enough. So don't complicate the life of everyone else, Jackson. I actually know the actor now. I was just watching an action movie last week, and as I was watching it, oh, I know this guy. He looks like a student of mine. Yeah, he looks like you, Jackson. Forgot the name now, but it's really, really, really well known. Okay, any other questions? We're good. every week, 2 minutes is recommended. Who I look like? Lucky for you, Jackson. Lucky for you. Okay.
Billable hours, Manjo. He'll be billing.
Yeah. Lucky for you. Okay. So, what role does the Freedom of Information Act play in administrative law?
Could this have any relation to that My Health that everyone's talking about as well, and you can opt in and opt out? Because that's information that's freed up to medical people that wouldn't be available if you opted out.
Possibly, but that's also and it's also related to the Privacy Act.
Yes.
Yeah.
But there is crossover.
Okay. It is, but in relation to administrative law. Remember, what is administrative law about? What is what is it about really?
Are you able to hear me, Mango? Mary?
Mary, I could hear you. Yes, go on.
To me, what it's about is it's about being able to apply for any documents that the government might hold, or the administration of government may hold, get a hold of them, or any documents that a government agency might have that pertain to you personally. Now, when you they may be about you personally, not from my own experience, but from dealing with other people, I know that it's often very difficult to get information about yourself personally from these, because they use the very wide statute of, oh, it's not in the public's best interest, particularly mental health, child protection, a number of areas. And so, like, in that regard, even if you appeal it to the commissioner, they would then say, no, we agree it's not in the public's best interest to know, so therefore we agree with them not releasing it to you. So whereas you can get certain documents pertaining to the administration arms of government and information about the government, it becomes much more difficult to get it when it relates personally to you.
Okay. Okay. Very good. Thanks for sharing that. So again, Okay, so we've got answers here. So thank you, Mary. We've got an answer from Ainsley. The Freedom of Information Act assists in ensuring government accountability or accountability of the executive. From Sarah Rogers, it also promotes transparency. Because at the end of the day, what we need to remember is that the executive wields, very, what you might call Leviathan powers. It wields very strong powers that affect the lives of citizens. Not only because they have, they have the power to determine what budgets. I mean, of course, it's going to be the parliament that determines that, but the way they actually allocate the budget that has been provided by law by the parliament is actually can actually be to a great extent determined by the executive, the decisions that they make that impact on citizens. So the executive, therefore, wields enormous powers. And the problem, however, is that the way that the executive may exercise its powers can often be very, invisible to the public. We don't know why the executive is making decisions in a particular manner. And so, therefore, the advantage of having the Freedom of Information Act, as pointed out by Ainsley and Sarah, is that, the FOI provides a higher level of transparency by providing the public a legal right to be able to access public documents in the hands of the executive. That certainly promotes transparency. So we have an opportunity now to know, why decisions were made. We can all, and by doing so, that will also ensure accountability on the part of the executive, knowing that the executive cannot just hide behind the veil of saying that, this is information that is so sensitive that the public must not know about it. So that assists, therefore, in controlling potential abuses or excesses in the exercise by the executive of its powers. And as pointed out by Jackson, it promotes scrutiny of the government, because that is what a democracy is all about. In a democracy, citizens should be given an opportunity to scrutinize decisions made by the executive. So, in other words, the involvement of the citizens shouldn't just happen during elections. It should happen, almost every day, by allowing the citizen to step in when it feels that there are abuses or excesses already committed by the executive. From Mary, my point was they obstruct the accountability and transparency by denying their RTI, or RTI means right to information, or FOI request, and even an appeal can be denied due to public interest, especially for individuals seeking that particular information. So this is a point, Mary, that we will be examining at this point, to what extent the executive can actually prevent access to the public. So can a minister, for example, say that, I cannot grant you access because the information is just too sensitive? The question then is, who has the burden of saying that the public cannot have access to the document? Is it the public seeking access to the information? Is the burden of showing that he should be given access? Or is it actually the minister who has the burden of justifying the denial of access to the public? So that's one thing we need to examine today. For Mary, that's right. They can appeal to the FOI Commission. And then there is that higher level of appeal. If a person is unhappy with the decision of the Information Commissioner, what is the option there? So what's the option? So let's assume that somebody, sought access to certain public documents and the executive refused to provide access. So that individual then went to the Information Commissioner. So if an individual is unhappy with the decision of the Information Commissioner, there is an opportunity to apply for review with the Administrative Appeals Tribunal. So there is that mode. If a person is unhappy with the decision of the Information Commissioner that might uphold a decision of the Board of Executive to deny access to public documents, there is an opportunity to apply for merits review with the Administrative Appeals Tribunal. From Lauren, there is recognition that information gathered by the government at the public expense should be widely available to the public. That's right. So public information is really part of public wealth. So it's part of the public domain. It's owned by the public. It's not something that's owned by the government. It is owned by the people. Okay, very good. Question 2. What are some of the conflicting themes in having a freedom of information legislation? What are some of the conflicting themes? What do you think? Is it all about the public having a legal right to access government information? So, for example, can the public seek to find out what the methods are of the ASIO, or look into decisions made by the cabinet during its deliberations? Can the public try to find out how the police may have their programs to monitor the possibility of the commission of crimes? So in other words, is there an absolute right on the public to access public information that is in the hands of the executive, or is it limited? So for Mary, you can have access to some information if the administration allows it. Okay, that point, would it be correct to say that the public only has access to information if the executive allows it? Would that be a correct statement to make? From Keith, subject to statutory carve-out. So let's go back to that question. Would it be correct to say that the public can have access to information only if the executive allows it? So in other words, does the right of the public to access public information depend on the executive allowing access to the public to the public information or to public documents? Is that the way it works? It depends on the executive? In certain circumstances, yes. But what is the rule? What is the general rule?
Is it the fact, Manjo, hi, it's Sarah here. Is it the fact the general rule is that you can have access to most information, but there are certain exemptions and certain exempt agencies whereby that there has to be a balance. There has to be a balance to say there is some items that are politically sensitive and in the public interest to remain secret, or confidential at least, whereas the majority of the information is publicly available and the minister has the burden of proving why it's not available.
That's right. So that is the general rule, as correctly pointed out by Sarah. There is a legal right on the part of the public to access public information and public documents in the hands of the executive. That is the general rule.
Manjo, I've just got one thing to ask.
Yes.
I think it's easy for us to say that this works and it's convenient because, for example, there's an application that I've had. I don't have the time to appeal it and go through all that. So I was denied a request. I know that this report relates to an ombudsman's report. I know it exists. However, they've deemed it as a cabinet in confidence document.
Yes.
Largely because it's probably going to be political and it'll probably, instigate four corners or something. But right. I know it exists and everyone knows it exists. However, it's been denied on the basis that it's cabinet in confidence. Now, the only reason they've done cabinet in confidence is because they don't want people having access to it. But at the end of the day, it's occurred. The Ombudsman has done a report, and there's hundreds of these sorts of reports that occur. And that's where I think that it's really on the government to be honest and for them to say, no, well, they can have this, whereas it's too easy for them to say this is cabinet in confidence.
Good point. So again, when we speak about freedom of information, the people, the public has a legal right to access public information and public documents only because there is a statute for that. It isn't a common law right. It is the parliament giving the public a legal right to access public information and public documents. And because it is a right given by the parliament, it is a right given subject to certain limitations. Among those limitations would be cabinet deliberations. Among the other limitations would be those that affect national security. Okay, but as a general rule, as pointed out correctly by Sarah, the public has a right to public information and to public documents in the hands of the executive. It is a legal right given by the executive, regardless of any reason why the public, or an individual may seek the document. It is a public right, subject to certain exceptions. So the burden then is not on the individual seeking access to the documents, why he should be granted access, or he or she should be granted access. The burden is on the executive to deny access. So that should be clear. So as pointed out here by Keith, under the Freedom of Information Act, the executive must allow access unless there is a statutory exemption. So that is the rule, okay, as correctly pointed out. As Nancy said, the general rule is everyone has the legal right, subject to exception. Among the exceptions, of course, as we know, correctly pointed out by Lauren, would be that those that protect third-party interests, such as trade secrets. Because certainly, if you have, there might be documents submitted to the ASIC or documents submitted to Intellectual Property Office. If you get access to those, then they won't be trade secrets anymore. That will impair the proprietary knowledge that may belong to certain companies or individuals. So there are restrictions. So for Mary, but it doesn't happen in practice from my years of experience helping others apply and what media are denied. So it's like from Mary, your experience, Mary, has been that you try to seek access and the government, the executive denies the request. Is that right? Yeah, okay. That might be correct. That could be correct. Jackson was saying the same thing. But so what you will then notice is that it was because of the Commonwealth Parliament that the Freedom of Information Act was passed. It was an act of the Parliament. It is the executive, that is running the government that is trying to limit what the Commonwealth Parliament has done by denying, by seeking to limit access to certain public documents. But it doesn't change the rule, one, that as a general rule, it is a legal right given to the public to have access to public information and to public documents in the hands of the executive. That is the general rule. And if the executive denies a request for access to public information or public documents, there is a remedy. One, you can always ask for an internal review, meaning bring it up to a higher, to a higher authority within the department or within the executive. If not, bring it to the Information Commissioner. Otherwise, go all the way to the AAT. And of course, decisions made by the AAT are of course subject to, judicial review. You can always ask the courts to examine decisions made by the AAT on a question of law, saying that the decision of the AAT is contrary to law. From Mary Moore, these documents sought are to do with corruption for the most part and seeking evidence of what we know. Even the AAT so often agrees with the commissioner. I have a question here actually that touches on this, Mary. It's about the submarine program in Australia. So we'll get a chance to examine that in a short while. So before we leave question 2, what exactly then are the conflicting themes in having a freedom of information legislation? Can I just get somebody to summarize for us the conflicting themes? Are there conflicting themes?
I guess it's because the legislation says that we can have access to these documents, but they've protected themselves with the exemptions.
That's right. So, but what's the purpose for the exemptions? Why are there restrictions on the right to public access? What for? Is it just a political move, or is there a sound reason for that on the part of the executive?
It's probably an ulterior motive to protect themselves.
Is it simply to hide corruption?
No,
Yeah.
it's for public. It's because it's even, you know, in Parliament, they've got that Parliament privilege. Not everything that they can say is going to be accessible to everybody, in case they're scrutinised and treated prejudicially. That's
right. No, but the thing is, can you imagine if everything that is discussed by the executive can actually be open to public scrutiny? Then the ability of the executive to make discussions, deliberate with full candor and honesty will be impaired, because they would be concerned that anything they say is going to appear in the media, right? So there could be chaos. So there have to be instances when, you know, deliberations, for example, with the cabinet has to be kept, you know, confidential. It cannot be, you know, the public can't have access to it. There will also be a need to protect, for example, operational guidelines of the police, because if it were open, you know, the criminals can make use of that. There was also a point earlier made by Lauren about the need to protect trade secrets. So on the one hand, therefore, there is a recognized right on the part of the public, based on the Freedom of Information Act, to have access to public information and public documents. But on the other hand, there is a need to try to limit the access of the public, because it will impair the effectiveness of government if, you know, everything can just be out there in the open. So, okay, so it can lead to tyranny and overthrow the government, from Mary. Okay, so we're good with question 2. Okay, so let's examine now, when we go through questions 3 to 6, we will get a chance about how these conflicts actually arise. In particular, when we look at the one about the submarines. You've probably heard about the submarine program in Australia, right? Where, you know, it's been constantly scrutinized. I just created a question about that. So let's go to question 3. Is this a quiz question? This is the quiz question. Can I get somebody to read question 3 for us?
Is my microphone working okay?
It is working, Kayla. It is working, yes.
Okay. At a family court hearing of the Federal Circuit Court on 16 June 2018, into the matter of child custody, the judge issued an interim order awarding custody over 6-year-old Colette to her mother. The judge issued the order as a result of the failure of Scott Rowland, a self-represented litigant and father of Colette, to submit an affidavit 5 days prior to the hearing to support his claim that he had completed the 6th session domestic and family violence seminar mandated by the court. During the hearing, Scott had tried to convince the judge, without success, that he had in fact completed the seminar and had timely submitted to the court registrar on 6 June 2018, at least 10 days before the hearing, the proper certificate of attendance as an annexure to his affidavit. The court registrar, however, had asserted during the hearing that there was no record of the annexure or the affidavit having been submitted at any time to the court. Scott was devastated by the court order. After the hearing, he went to the court registry in order to examine the court documents pertaining to the submission of his affidavit and annexure. The court registrar, however, said that notwithstanding the Freedom of Information Act, she could not release any court documents that would shed light into whether or not Scott had in fact submitted them on or about 6 June 2018. Scott has come to you, a solicitor for legal advice. What advice would you give him?
Thank you.
Which of the following statements is the most correct? A, Scott has no right to apply for access to the court documents pertaining to the submission of his affidavit and annexure, since the Freedom of Information Act has absolutely no application to a federal court, such as the Federal Circuit Court. B, Scott has the right to apply for access to the court documents pertaining to the submission of his affidavit and annexure, as these matters are arguably of an administrative nature. C, Scott has no right to apply for access to the court documents pertaining to the submission of his affidavit and annexure, since those court documents are exempt documents under the Freedom of Information Act and cannot be subject of a request for access under the Freedom of Information Act. D, Scott should file an administrative complaint against the judge for his behaviour. E, all of the answers are incorrect.
Okay, thank you. Thank you, Kayla. Is that the way I should pronounce your name? Is it Kayla or Kaylas? Because I see an S there.
Oh, is there an S? No, it's just Kayla.
Okay, there's an S right now.
Oh, there is.
I got confused. Yeah, okay. Thank you. Thanks for reading it. So can I get everyone to try to post an answer in the chat box? So from Nicholas B, others from Mary E. Most are answering B. Okay, very good. Okay. Okay. So almost everyone has answered letter B. Can I get somebody to explain why that is the correct answer? Why letter B?
Well, you should be able to see, you know, if you've submitted something on date, for starters, straight away.
Sorry, Michael?
So I got bad internet. I'm on my mobile. I'll type.
Okay.
Section 5 of the Freedom of Information Act.
Yeah.
Extends the right to request court documents if they're of an administrative
That's right.
nature.
Very good. So that's under section 5 of the Freedom of Information Act. The Act doesn't apply to any request for access to documents of the court unless the document relates to matters of an administrative nature. And if you look at Klein versus Official Secretary of the Governor General, when the court documents do not actually relate to the substantive functions of a court, then they are considered to be of an administrative nature. So the correct answer is letter B, as also correctly pointed out by Keith. Let's examine another question now. So thank you. The correct answer is letter B. Scott has the right to apply for access to the court documents pertaining to the submission of his affidavit and annexure, as these are matters that arguably are of an administrative nature. That is the correct answer there. Thank you.
My question, can I ask a question about that?
Yeah.
It's his own court case. He's a party to that case. So in filing it, he would have a sealed copy of the court and he would have to serve it on other parties. So therefore, there would be evidence for him to hand up to the judge of the sealed copy that he would have received. That's what I don't understand. That's why I chose E, because I thought the way that the whole court process works, which I'm very familiar with, you know, that is evidence within itself. You don't file a single original once only affidavit to the court. You've got to file the original plus the copies that go to the other parties and keep a copy yourself, and they're all stamped and sealed by the court.
That's correct, Mary. The thing is, we're limited by the facts here. Okay.
So what you're saying is this answer is directed only
based on the facts.
Freedom of information.
Yes, for us, the legal issue really for us is, was the court registrar correct in denying the request of Scott to release documents that would shed light on whether or not he had in fact submitted the affidavit?
Okay, so that's
the legal issue. Now, whether or not it was actually sorry, yes.
Yeah, that's okay. I understand. B would have been my choice, but I just
okay.
B because
right.
of knowing how the system works. That's all.
Yeah, typically if it's an affidavit that's submitted, he would have had proof that he actually submitted it. That's right. Okay, but based on that, if we're just looking at the legal issue here, the legal issue is whether or not the court registry was correct in denying the request to release documents. So because if it is of an administrative nature under Section 5 of the FOI Act, it is a document to which Scott could have access to. Seems a bit unfair not to allow it. Let's look at another question here. Almost the same one. Let's look at question 4 now. Can I get somebody to read question 4?
I'll do it.
And thank you.
Olive Adams, a self-represented litigant and father of Colette, was very upset after the court registrar issued an interim order awarding custody over 6-year-old Colette to the mother at a family court hearing at the Federal Circuit Court on 20 November 2017 into the matter of child custody. The court registrar issued the order based on the family report issued by the court-appointed family report writer. The registrar, citing confidentiality, had denied Adams' request for a copy of the family report. Olive has come to you as solicitor for advice. He wants to know if he can use the Freedom of Information Act 1982, Commonwealth, to compel the disclosure to him of the family report. Assume that the court registrar can lawfully issue the court order. What advice would you give him?
Okay. Thank you, Jackson.
Oh, there's no A, B, and C. Okay.
You think that Olaf has the right to have access to the family report on the basis of the Freedom of Information Act?
If he's a party to the case and he it's on the court register, then arguably yes. Same as the last question, he should have access to it.
On what ground? Because he's a party? Is it because he's a party to the case, therefore he has the right to access?
Technically, yes, because he has an interest in it. He would, as a party, fundamentally be granted access.
Uh-huh. Well, what would his basis be? Is it the Freedom of Information Act in that case? Or is it a matter of court proceeding?
It could be both. He could make an application under the court proceedings, but he could also, as a party, but he could also say that under the Freedom of Information Act, because it's pertaining to his particular case, and because it contains the information relating to him, then he should be entitled to see it and correct any errors if there are any.
Okay, so in this case, the registrar actually is acting in behalf of the judge. Does it mean, therefore, that if the judge denies a request of a party litigant to have access to a document such as a family report, an applicant can actually go to the Information Commissioner to compel the judge to provide a copy of the family report to an individual? Is that the way it works?
The judge can't be compelled to release their own notes.
Yeah.
No, that's correct. So I would say no. If they're acting in a judicial capacity, then no. You would need judicial review, as Kayla's just written. So in that case, if he's acting as the judge, then no, you wouldn't be able to have that.
The basic legal issue really is whether or not the document, the family report, relates to matters of an administrative nature. That is the basic question there. Is the family report a document that relates to matters of an administrative nature? That is a basic question. And in this particular case, I would think that it is not of an administrative nature. It goes back to the substantive functions of the court to try to determine what the proper parenting order might be. And in that particular case, therefore, in trying to determine what the proper parenting order might be, it is in the exercise of the powers of a judge to determine what documents should be held in confidence and what shouldn't be held in confidence. So the proper remedy really, in the case of a denial, is not for the information commissioner to override the decision of the judge, but to ask for example, for the judge to reconsider the order made by the registrar. So this, to me, wouldn't be an example of an administrative of a document of an administrative nature, because it goes right into the exercise of the substantive functions of a court. Following the case of Klein versus Official Secretary of the Governor General. Okay, questions? So from Keith, this may not be held to be an administrative document. If not, then he has no right under the FOI. That's right. So what we need to remember is that if you examine it, so we have three branches of government, right? You have the executive, you have the judiciary, and you have the parliament. Which branch of government does the information commissioner belong to? Let's clarify that. The executive, right. Can you imagine, therefore, if it would appear that the executive, through the information commissioner, has the power to override decisions made by the judge? That would violate the separation of powers. That's going to be impermissible under the constitutional law framework. So what we also need to remember is that when it comes to a federal circuit court, with a federal court of Australia for that matter, these are actually creations of the Commonwealth Parliament to create federal courts. But even then, because they create the courts, they can impose certain restrictions. They can even determine what the jurisdiction might be of the federal courts or the Chapter 3 courts that they create. But they cannot impose restrictions or limitations that impinge on the separation of powers or would limit the independence of the judiciary. The judiciary won't allow that, following the Boilermakers case, for example. So you cannot have a situation where the information commissioner is able to override decisions made by the judge or by the judiciary in the exercise of their substantive functions. So Section 5 of the FOI is quite clear that it is only when a document relates to matters of an administrative nature that the public can have access to that document. But otherwise, if the document relates to substantive matters, meaning those that relate to the exercise by the judiciary of its powers, then there can be no access to the public as a matter of right under the Freedom of Information Act. Okay, thank you. Very good. Let's go to question 5. Can I get somebody to read question 5?
I can read it.
Thank you, Lauren.
Gail Ashgrove decided to pursue a Master's in Political Studies at an Australian university and applied for a scholarship under the Research Development Scholarship RDS Act Commonwealth, administered by the Australian Department of Education. The Act provides that research development scholarships shall be awarded on the basis of academic merit. It also provides that the Minister of Education, the Minister, shall head the RDS Selection Committee. Having graduated with first-class honours from the University of New South Wales, Gail was confident that she would get a research development scholarship. However, she had some apprehension about getting a scholarship because the Minister had shown, during a TV interview, a bias against students who protested against the visit of the Chinese Premier in Canberra, during which a major student disturbance had taken place. Gail had led the student protest during the Chinese Premier's visit and had even engaged in a heated shouting match with the Minister at that time. Gail subsequently received a brief letter informing her that her scholarship application had been unsuccessful. No reason was provided for her rejection of her scholarship application. Gail has come to you, a solicitor, for advice. She wants to know if the Freedom of Information Act 1982 can help her in finding out why her application was rejected.
Okay, thank you. So Travis remembers this woman. Yeah, you've got a good memory there, Travis. We've met Gail before, but it's a different question this time. This is a different question. The question this time is whether the Freedom of Information Act can help her in finding out why her application was rejected. That is a different question now. I think this question was asked in relation to the right to natural justice, whether the failure on the part of the minister to provide her reasons was a breach of the right to natural justice, or whether or not before the minister denied her application, she should have been given an opportunity to, explain why her application should be accepted and not denied. That was the legal issue then, pertaining to natural justice. The question now relates to the Freedom of Information Act. Can the Freedom of Information Act help Gail in finding out why her application was rejected? So from Keith, yes, there's no reason why the FOI would not apply. But the basic question is, how would, assuming that the FOI would apply, how would it help the case of Gail? Assuming the FOI Act applies, how would the FOI help Gail? Okay, from Mary, she may or may not get the answer she seeks. Okay, go on. To be more specific, from Keith, because then the minister would need to release papers pertaining to her application evaluation process. So that is the advantage of being able to use the Freedom of Information Act. Fine, the minister doesn't have to provide reasons, but because of the Freedom of Information Act, Gail can compel the minister to share documents relating to her application and find out why her application was rejected. Can you see the advantage there? So that's how the Freedom of Information Act can help, by compelling the minister to provide information, for example, as to how other applicants were assessed, how her application ended up being rejected. From Keith, it just depends on how deep Gail's pockets are. There is no cost, as far as I know, there is no cost in applying to the Information Commissioner for a review of a decision by an executive that denies access to the public of public documents. There is no fee. Or if there's a fee, it's going to be minimal. So in the event that the minister denies the application of documents pertaining to Gail's application, she can always go to the Information Commissioner. From Jackson, unless it becomes a cabinet in confidence, it's going to be very unlikely, because how can the cabinet come in here? It's not going to be every single case that just because the minister would say that it was a cabinet deliberation and therefore held in confidence, that the Information Commissioner would necessarily side with the minister on that ground. Okay, and we're going to examine that on the next question. Any questions on question 5 in relation to question 5 before we go to question 6? Because we're going to...
Yeah, just the deep pockets question. Sooner or later, you're going to end up in the AAT because the minister's going to resist.
Okay, that's your point.
Yeah, so, and you're going to need representation, blah, blah, blah.
Right. True. Yeah, that's right. So there will have to be a cost. There will have to be a cost. But at least we know there is an opportunity to access these documents. And you would think, hopefully, that the minister would not deny the request for access to these documents. Certainly, as correctly pointed out by Mary, judicial review would be very costly because you would need a solicitor for that at least. Okay, but the point there is you can use the Freedom of Information Act to access documents. Okay, Kayla, see you soon. See you on Monday. Okay, finally, we go to question 6. Nicholas, I've heard very little from you today. I've heard your voice though. Are you there still? Nicholas is no longer there. Okay, can I get somebody then to read the final question for us? Discussion question 6.
I'll do it, Manjo. It's Sarah here.
Thank you, Sarah.
No worries. Eaglewood Australian Submarines lost in its bid to build submarines for the Department of Defence under its Future Submarines programme. It accused the Department of Defence of treachery in awarding the contract to a French tenderer and complained to the press of possible illegal behaviour by Department of Defence officials in the bidding process. The Go Australia Go movement, a group of patriotic Australians, subsequently asked the Department of Defence for access to documents that showed how the French tenderer was chosen in the bidding process. But the request was refused by the Defence Minister, citing the lack of any legal standing and legitimate reason of the movement in asking for the document. The Defence Minister also said that the documents were exempt on the grounds of national security. The movement has come to you for legal advice. What advice would you give?
Thank you, Sarah. I'll see you soon, Travis. What advice would you give the movement?
From reading quite a bit, the Department of Defence, that seems to be one of the broad categories where they seem to have quite a lot of exemptions on national security.
Mm-hmm. Okay, there are three legal issues here. One is the fact that the movement seems not to have any legal standing. Is that even relevant to the issue of whether or not it can be granted access to these documents? Number two, do they have to provide legitimate reasons? That's the second legal issue. And then the third legal issue is whether or not the documents do not have to be released to the movement because it is exempt on the grounds of national security. So those are three legal issues there. In relation to legal issue one, what is the answer there?
You don't have to prove standing to put in an application for FOI.
Very good. So that's the first legal issue, correct? You don't have to prove legal standing. How about legitimate reason?
Equally the same. You don't have to provide a reason. That's
right. So the fact that a person may actually have no legal interest in the document is not a ground for denying the application for the request to access public documents. Neither is there a need to provide any reason why anyone would wish to access certain documents. So that's clear. Now, in relation to the third legal issue, whether or not the documents can be said to be exempt on the grounds of national security as a ground for denying the request, what do you think of that? Jackson raised a good point here. It could be exempt under Section 47, documents disclosing trade secrets or commercially valuable information. Okay, we're going to get to that. For now, the reason for the denial by the minister of the request is that the documents are exempt on the ground of national security. So first
that
question
one would probably fly.
Yes?
Or float in this case.
Sorry, Keith, I kind of missed you there. What was it?
It was only my warped sense of humor. I said, or float in this case.
Sorry, I missed that. I'm probably having my problem with my hearing. What was it? Okay. Float in this case. Okay, there you go. Very good. Okay. Thank you. No, not fly. Okay. Okay, so there are two aspects to this issue, to the third legal issue. Number one, is the Department of Defense or the Defense Minister considered an exempt agency? Because if it is an exempt agency, then all of these documents are exempt from the public. The public can't have access to documents of an exempt agency. So that's question one. Is the Defense Minister of Defense considered an exempt agency? Second question is, would that be considered an exempt document? So from Keith, no, it is not an exempt agency. So that's correct. The Minister of Defense is not an exempt agency. Good. So if it is not an exempt agency, the question is that particular document considered an exempt document on the ground that on the ground of national security, it shouldn't be released?
I would think it is.
Okay, go on. Roxy, why?
Oh, no. No, just by reading it and stuff, if you're building submarines, it's obviously, I don't know how to explain it, but I would just think that it would be due to natural, I can't even say it now, the security reasons, but I don't know, I find it hard to explain. Just by reading the question, I automatically thought, no, he wouldn't be able to access the documents but it depends on what they're building them for. If it's defense for like, you know, for the army and things like that, I would say he couldn't access them based on that.
Now, remember the reason why the Go Australia Go movement is seeking access to the document is really to find out if the bidding process was rigged.
Oh, yeah.
They're not trying to seek access about, you know, what the technology is of the French tender, or whether or not their technology is better. Their goal is to find out if, you know, the bidding process might have been rigged.
Yeah.
So, in other words, can the defense minister just, you know, come up with a blanket reason to say that, you know, we can't release the document on the ground of national security? Is that enough? Because if the Minister of Defense is given that right to just say that, you know, it cannot be released because on the grounds of national security, that ground can be used anytime. And does it mean, therefore, that it is beyond the ability of the Information Commissioner, for example, to review a decision on the part of the Defense Minister citing the ground of national security as a reason for denying the request for public access?
Maybe this is completely out there, but is this not like to do with contracts, and so is it not under the general law? So can they still, I just feel like there's something more, because they're entering into contracts here. Is it arguably the fact that that the bidding process necessarily could be available because it's under the general law, and because it's not necessarily to do with national security in the sense that it's a contract, then it is separately away. It can be argued that it's separate from any kind of army or navy kind of linkage.
Okay, that's actually related to Jackson's point about Section 47. We're going to go back to that in a short while. That's kind of related to what Jackson was saying. But in relation, though, to the legal issue that the documents do not have to be released to the movement because of grounds of national security, how cogent and strong is that reason? That's really my question. And then we go back to that issue about contracts and Section 47. So the point here is, I think Keith made the point that the onus of proof would always be on the minister. The minister has the burden of proving that he has a legitimate ground for denying the request for a public document under the Freedom of Information Act. It should be clear that under the Freedom of Information Act, under Section 33 in particular, the document can only be considered an exempt document on the ground of national security if there is a chance that it will reasonably damage or cause damage to the security of the Commonwealth. So that is the onus on the part of the minister. The minister must be able to establish and show and justify that by releasing this document, it would or could reasonably be expected to cause damage to the security of the Commonwealth. Do you think that is a plausible reason there? So the point there is that there is ground to, as a solicitor, you could probably argue that you would think that national security as a ground for denying the request for public access to the public document might be a weak excuse, might be a very weak justification. So you could probably say, you will go anyway to the Information Commissioner to review the decision of the Minister of Defense, because it's difficult to see why the release of the document would impair or that cause damage to the security of the Commonwealth. And remember that the goal of the Freedom of Information Act in the first place is to promote public accountability and scrutiny of government decision making. If there is a possibility that there might be, that the bidding might have been rigged, that really is a justification why these the public documents should be shown to the movement. Okay. Now, so as a lawyer, you could make that advice on the ground that, you know, you can just bring it up to the information commissioner because you don't believe that it meets the requirements of being an exempt document on the ground of possible damage to national security. Now, on the point made by Brad and Sarah earlier that it could contain documents disclosing trade secrets or commercially valuable information, that again is a valid point. So we can see now the possible exemptions, right? Okay, but again, that's correct. But again, only the Minister of Defense can always release those documents that may not end up disclosing trade secrets or commercially valuable information. But the Defense Minister cannot use that as a blanket excuse to say that he's not going to give out documents at all, because some of those documents may not have any relevance to trade secrets or commercially valuable information. Instead, if the focus of the request is really to look into or to scrutinize the way that the bidding process was done at the Department of Defense, then there is no reason why the documents will not be given to the Go Australia Go movement. Okay, so we've covered all the 6 questions. Any comments, questions before we end tonight's session? So we're good. Okay then, thank you very much. And so as I pointed out, although we discussed hopefully in detail or extensively the topic under the Freedom of Information Act, I will not assess this particular topic. It's a bit too complicated for me. We'll instead just focus on week 6 to 10. Okay, I know that Jackson likes this a lot. It's pretty evident. He's even identified Section 47 there. He's very familiar with it. But Jackson, you're the outlier. You're the only one who knows a lot about this. So.
Oh, that's no good because I've got a couple more FOIs in the mix, and I know that the thing that you just said then.
Yeah.
Said that just because I sound like a serial pest now, but the blanket for everything. I know that there's a government agency who's done that because they've gone, oh no, it covers all of that, and I'm going, well. Otherwise, give me just the cover page, at least. That's not covered by confidence, at least.
That's right. That's right. That's correct.
Yeah, but it doesn't work that way. We all know how it goes.
Yeah, I know. That's right. That's right. Okay, then. So thank you very much, and I'll see you guys on Monday.
So just for Monday, the tutorial that we're doing, are we kind of just going over any questions or queries we have before the exam?
Sorry, Rocky, what was it again?
So Monday's tutorial, are we just kind of just touching base on everything again and just prior to the exam? That's kind of what the plan was.
So during the revision, I will provide directions on what the possible topics will be that will be covered. So I'll be more specific this time. Instead of saying just about week 6 or week 7, I'll draw your attention to the themes within a particular topic that is most likely going to be assessed. That's one. And then secondly, I will provide some suggestions on how you should answer the questions.
Okay. Just because I won't be here on Monday, so I just
Okay. Yeah. You just make sure to watch the recording though.
Yeah. Okay.
Okay. So have a great weekend, and I'll see you again on Monday. Bye. Thank you, Jackson. Bye. See you, Sarah. Bye.